O Congresso Internacional da Associação Brasileira da Propriedade Intelectual chega neste ano de 2020 à sua 40ª edição, totalmente digital e online, como os tempos estão a exigir. Este ano o compromisso é proporcionar uma oportunidade única de engajamento nas discussões mais relevantes sobre o papel da propriedade intelectual na transformação digital. Serão 4 plenárias, 8 painéis e 16 table topics, onde serão abordados os assuntos de maior interesse do momento pelas personalidades mais influentes do cenário da propriedade intelectual, gente do mundo inteiro, já que a internet nos aproxima de tudo e de todos ainda mais. Transformamos o desafio virtual numa oportunidade para inovar e oferecer uma experiência mais cosmopolita, rica e ainda melhor. Inovamos no formato. Vídeos vão apresentar o tema e seu contexto. Palestras curtas e objetivas vão explicá-lo. O debate aberto ampliará a compreensão de diferentes visões e teremos ambientes virtuais de interação face-to-face para que se abram oportunidades de negócios. Está mais fácil de participar, sem custos de deslocamento nem hospedagem. Tudo isso com acesso livre e exclusivo para os associados da ABPI. Se você ainda não é sócio da ABPI, associe-se já e garanta assim sua participação no maior congresso de propriedade intelectual da América Latina.
Good morning. On behalf of the Brazilian IP Association and the World Intellectual Property Organization, we welcome you all to our new edition of IP Meetings, a series of webinars about the most relevant and current topics on IP, organized by Wipo and the Brazilian IP Association in partnership. Thank you very much for joining us for today's webinar. We welcome the authorities connected here with us, Mr. Luiz Edgar Montauri Pimenta, President of ABPI. Mr. José Graça Aranha. Mr. José Graça Aranha, Regional Director of the World Intellectual Property Organization in Rio de Janeiro. And we also welcome our special guests, Mr. Felipe Daneman Lundgren, President of the IP Committee of the Brazilian Bar Association. Mr. Luiz Henrique do Amaral, Vice President of AIPPI, International Association for the Protection of Intellectual Property. Mrs. Maria Beatriz Delori, Regional Intellectual Property Advisor for Mercosul, Guianas and Suriname. Mr. Marcelo do Nascimento, President of ASP, São Paulo IP Association. Mr. Paulo Parente Marques Mendes, Delegate of the Inter-American IP Association and President of the Brazilian Group of the International League of Competition Law. Please feel welcome. We are now opening this ceremony with the welcome remarks by Mr. Luiz Montauri Pimenta, President of the Brazilian IP Association.
For you that are in Geneva, and I would like to welcome to this webinar our panelists, Mr. Noam Shemtov from Queen Mary University of London, Mr. Dimiter Gantchev from Wipo in Geneva, and our colleague Fabio Barbosa from our representative, ABPI's representative in São Paulo. I'm sure he will be presenting you much better when Fabio took over the words. And from ABPI, I would like to congratulate Wipo and thank you, Wipo, for the organizing this webinar with us. This is a very interesting topic. very modern. ABPI is trying to work more and more in the last 6-8 months, especially because of the situation that we are facing worldwide. And we think we are being successful in such venture, and are working virtually in all fronts. In our webinars, a lot of podcasts, lives, and our annual congress that will take place soon from the 19th of this month until the 22nd. And we at BPI would like to welcome you and invite you to participate in our congress with very interesting topics. So I don't want to take much of the time of the speeches, and we'll pass on to José Graça from Wipo for his words. Thank you very much.
Good morning, everyone. Mr. President, it is a great pleasure to be here today for another event jointly organized by the Brazilian Association of Intellectual Property and the World Intellectual Property Organization. I thank again ABPI for the co-organization of this event, and I thank my personal friends, Autorais, for making it available. Wipo is in fully teleworking mode. This is the positive side of this difficult time we're going through, this pandemic that brought of us and forced us to be more efficient in order to perform our work. So as the president of ABPI mentioned, we have people from Geneva and from London today. He already mentioned Noam Shemtov from the Queen Mary College in London, and my colleague and friend Dimiter Gantchev, the director of the Copyright Management Division at the headquarters in Geneva. I welcome both of the speakers and all the participants, and I wish everyone a good event. Thank you.
Sir, thank you, Mr. Graça for your kind words. Thank you all again for joining us today. If you have any question, I kindly ask you to wait until the end of the session when you'll be able to publicly make your question. I wish you all a nice webinar. Mobile applications have become an essential part of daily life in the digital world. The mobile app economy has indeed grown exponentially, driven by a huge community of software developers, as Mr. Noam remarks in his recent release on the subject. Following the growing demand for legal clarity on the potential of IP to increase income streams for creators and right holders, we will talk this morning about the importance of intellectual property aspects that directly affects this community. And of course, we are very proud to have Mr. Noam and Mr. Dimiter clarifying the subject for us this morning. We will give the floor to our moderator, Mr. Fabio Pereira. Fabio Pereira is a partner at the IP practices at Veirano Advogados. He holds a LLB from PUC Rio de Janeiro, a postgraduate degree in civil law from the Escola Superior de Advocacia, and LLM in intellectual property from Queen Mary and Westfield College, University of London, awarded in the British Chevening Scholarship by the British Council. He is the coordinator for the Dispute Resolution Commission and a member of the Executive Intellectual Property Association. Mr. Fabio, the floor is yours.
Angel Saraya for the kind words. It's a pleasure to welcome Noam and Dimiter to these IP talks. The subject matter of our discussion is actually very, very handy and unique. So it's something that is becoming our daily life, part of our daily life. I mean, mobile applications, as Erica mentioned, are really something that we use day by day. And then with the pandemic, we say that technology was forced into us somehow, and we advanced a few years in technology. I will introduce Noam. So Dr. Noam Shemtov is a reader in IP and technology law and a deputy head of CCLS. CCLS is the Center for Commercial Law Studies at Queen Mary. He lectures in the areas of IP and technology. His research interests are also focused in those fields. Noam has led researches and studies funded by the UK research councils and by industry national, supranational commercial organizations such as Microsoft, EPO, European Space Agency, Foreign Commonwealth Office, the UK Department for International Development, and Wipo. He's currently leading a project for GFID-FCO on the establishment and operation of a specialized IP court in Ukraine, acting as an expert in Wipo project and in the IP ecosystem of mobile applications, enjoyed with Agrans Ltd, a project funded by the European Space Agency. Noam also holds visiting appointment by Spanish and Dutch universities, where he lectures regularly. He's a qualified solicitor both in the UK and in Israel. More than that, Noam is a very good friend of mine, so I'm very happy to listen to him again after so many years. I remember the passion 15 years ago when I was at Queen Mary, the passion from him giving his lectures, and it's really a lecture, so it's something that it's worth listening. And when I was seeing his presentation earlier today, it came to my mind his voice and his knowledge about all those things. So I'm very glad and fortunate to have Noam with us. Once Noam has a chance to speak, then I'll present Mr. Gantchev. So thank you very much, both of you, for joining us. And please, Noam, it's all yours.
Thank you. Thank you, Fabio, for the kind words, and it's a real pleasure to meet again in this context. I would also like to thank ABPI for organizing this event and inviting me to speak to you all today, and to Wipo, of course, for running the project that Mr. Gantchev would explain and discuss a little bit later. And in particular, indeed, in this context, to thank Mr. Gantchev from Wipo, who really can be described as the one who fathered this important project from its inception to its execution. Thank you, Dimiter. And now, with your permission, I will turn to the topic of today's discussion. So if we can have slides. Next one, please. Next slide, please. And the next, please. Next slide, please. Okay, very good. So, what could be protected in relation to mobile applications, and what I will focus on today is the following: code and architecture and user experience. Next slide, please. And when we look, you could see that user experience was indeed emphasized, and I will explain in a little bit why is it that, to my mind, it is probably the most valuable asset in the context of a mobile app, but very possibly the most tricky to protect. which IPRs are relevant? In one word, all. It is really a tapestry approach that I would advocate for, where different rights protect different facets of a mobile app. If you can continue to click, please, as though you're moving to the next slide. Yeah, and another one, and another one. Thank you. So, in the case of copyright primarily protects code, sometimes elements of the software architecture in question, and some elements of the GUIs. By the way, when I refer to GUIs, I take it that most people here are familiar with the term. It's graphical user interfaces. Patent law can protect certain functionalities. It is far from straightforward in the case of a mobile app, as it is actually in the case of software-based products in general. Designs, industrial designs, or as I believe you call it in Brazil, design patents, could be very effective in the case of GUIs. Trademark and trade dress, both in a traditional sense, as well as in relation to GUIs elements. Trade secret, exceptionally important, both in the case of pre-launch, so before you launch your application, but also in some cases post-launch. And a little bit more on that later on. And of course, unfair competition in general in relation to some unfair trade practices, but also in relation to elements of the GUIs where somebody decides to borrow, let's call it like this, an insignia of your business as encapsulated in a GUI. Next slide, please. So, let's start with code and architecture, right? Those things which are below the surface, which we cannot as users see when or experience directly when we are using or accessing a mobile app. Next slide, please. So, copyright, again, I'm not going to go through the basics, so I'm going to run through these slides fairly rapidly. We know that copyright protect literary works. We know that literary works also include a computer code that is old news, more than a few decades. And therefore, the underlying code of a mobile app may be protected. Whether it's a source code or object code, it's fairly irrelevant for our purposes, may be protected for copyright law purposes. Now, how important that is, who is likely to copy your code? A plagiarist, a pirate. A competitor is not likely to be as silly as to copy your own code. And therefore, in that case, probably, although a very important tool, I wouldn't rank it very highly in this context. When it comes to architecture, it becomes a little bit more interesting because architectural elements of software, such as the architecture as a whole, certain algorithms, data formats, and so on. The main question in most jurisdictions would be whether they are protectable in the first place. And in that sense, you would ask yourself, is it likely to fall on the idea or the expression side of the idea-expression divide or the idea-expression dichotomy, which I assume most of us are familiar with? I mean, if you look at the European Union software directive and you look at the recitals, it actually explicitly states that, for example, in the case of algorithms, to the extent that an algorithm constitutes an idea, it is not protected. Of course, the million-dollar question is, when does something cross the borderline from idea to an expression? Which type of algorithms is an idea? Which type of algorithm is an expression? And I'm afraid that the answer is far from straightforward. It is very fact-specific and would be decided on the basis of the case or each case, right, on an ad hoc basis. I think that generally speaking, we can say that as long as a case is as long as the element in question is detailed, the more detailed it is, and if the copyist engaged in a verbatim copying, it is more likely that your argument for copyright infringement would prove successful, and vice versa. The more amorphous the thing in question is, the more basic it is or conceptual, the more likely it is that the court would find it to be an idea rather than an expression. On top of that, certain elements, architectural elements, may also be excluded from protection because they are dictated by functional consideration, and I emphasize dictated. I came across various misconceptions in this context in various places around the world, both with mature and less mature IP systems, whereby people would tell me that if it is there in order to perform a functional or to achieve a functional objective, it cannot be protected by copyright law. That is simply not true in most places around the world. The fact that it is there in order to achieve purely a functional objective should not be a problem as far as copyright law is concerned. The question should be, is it dictated by functional consideration? Did you have a choice? Let's say that you're the developer or the programmer. And if you didn't have a choice, then it is dictated and then it will not be protected. But let me put it to you that it would be exceptionally rare where the hands of the developer or the coder would be tied to such an extent that they would not exercise choice in this context. Next slide, please. So, as we said, the code is clearly protected, valuable up to an extent. Architecture depends what we are talking about. What is interesting to consider in that context is that the functionalities which are underpinned by this architecture and code are not really protected by copyright law. So, for example, one decision that comes to mind, the EasyJet decision in the United Kingdom, now a good, I would say, almost 15 years old. The court made it clear there, and I believe that would be the case in most instances, that, for example, the business logic that sat at the heart of, in that case, it was an app, although not a mobile app, an app that sat on a computer, a desktop. The business logic, as creative, as innovative, as fantastic as it is, it could not be protected under copyright law. It's simply not the subject matter, the type of subject matter that is protected under copyright law. And therefore, I mean, effectively, the end result is that in such a case, as far as copyright law is concerned, the defendant may appropriate it with impunity. Next slide, please. Patents. Again, I'm referring here to patents in the context of code and architecture. Code per se is not protected by under patent law. Less significance in the context of patents. In most patent applications, you are not even required to provide the code. Architecture may be protected to an extent, as I say here, that it underpins a functionality that is part of the claimed subject matter. For example, in the EPO, European Patent Office, architecture of the computer system may be protected as long as it is technical. In the US, you would say as long as it is not abstract, or if it is abstract or the subject matter claim contain an abstract idea, there is enough of an extra element in order to imbue it with patent protection. And it really depends on the patent application in questions. For example, and apologies to those here who are less familiar with the ins and outs of patent law, but if your claim is reading a specific architectural design that improve certain technical end results or technical parameters such as performance, efficiency, latency and so on, or you're creating a design which is based on several optimizations that result in measurable improvements to a computer system, that you may be on to something. Now, how often does that happen in the case of mobile apps? Not that often, but there are definitely instances out there where patents were granted to mobile app, the functionalities that underpin certain mobile apps, but it is a minority, a very, very small minority. The vast majority of mobile apps, including very successful ones, are just not eligible to patent protection. Next slide, please. Another thing that you need to remember, I mean, not only that what you have is technical and so on. Of course, it is. You have to satisfy the general patentability requirement of the thing in question. The claim subject matter must be novel and non-obvious or inventive, as we say in Europe, There is another element, and this is in a way a combination. This is a strategic decision. Let me explain. What you need to bear in mind is the requirement to provide, as part of your patent application, an enabling disclosure. An enabling disclosure, so where the person skilled in the art, it's disclosure which is sufficient so that the person skilled in the art may carry out the invention without undue burden. So you need to give the ins and outs of your innovation so that it would be obvious to the person skilled in the art and would enable him or her to carry out the invention. Now, there is a trade-off here, clearly, with trade secrets. You're basically saying, I'm happier with a patent, and therefore I'm giving my crown jewels, if you would like, or I'm disclosing my crown jewels in the patent application, and therefore I know that it's not going to be retained as a secret, but I'm going to have the patent system protection for 20 years if I'm lucky, and that's good enough. That's good enough for me. Next slide, please. As I said before, there is a trade-off with trade secrets. You're basically preferring patents over trade secrets, and some people would say, well, that's obvious. If you can get a patent, you should have a patent. If you can't, then fall back on some other IPRs to the extent that trade secret law is indeed intellectual property right, which is not necessarily straightforward. But my point is as follows, and I put it to you. Even if you can get a patent, it doesn't always mean that you should get a patent. Sometimes it actually it is better to rely on trade secrets. And that will change from one case to another. Now let's look at trade secrets for a second and its business impact. First of all, we know that every intellectual property right is born as a trade secret. It starts with a trade secret. I can go with you through all the intellectual property rights, irrespective of the sector in question. And at least at the very early stages, things would be maintained under secrecy, or better maintained under secrecy as a trade secret. Now, you can protect your code, your algorithm, your internal structure of the app prior to its release. Actually, you should probably do it. So pre-launch, there is a lot of logic in you maintaining those assets or holding those assets as a trade secret. You maintain the secrecy, preferably through contracts that include either NDA clauses or full agreements, NDA agreements to that effect, whether with employees or subcontractors and so on. So you make sure that any disclosure that you make of such valuable information or assets is subject to a confidentiality or a secrecy requirement. But you need to bear in mind a few things in that context. As far as trade secrets are concerned, trade secrets is no defense against reverse engineering. So once you release something out to the market, and technically people can work it backwards or reverse engineer it in order to access those assets, those golden nuggets. The fact that this thing is maintained as a trade secret per se is not effective against such practice of reverse engineering. You may try to beef it up with extra contractual prohibitions, and then it depends on the jurisdiction in question whether such contractual prohibitions are actually effective. But I put it to you that even if they are not effective, even if someone can go and reverse engineer it, it's still worthwhile to look after your assets under an effective regime of trade secrecy, because pushing someone towards reverse engineering means that someone, depending on the circumstances, but in a lot of the relevant circumstances in our context, that someone would have to go through a very time-consuming and costly process, which in the end of the day, they may say, you know what, it's not worth the bother. I'm just not going to go there. The reverse engineering can be extremely expensive to carry out, time-consuming and not accurate. So some people may say, I'm just giving up, I'm not going to bother with it. Or, depending on the circumstances in question, they may come to you and say, you know what, I'm interested in that particular piece of information, I'm willing to pay for it. So take a license. Again, it depends on the circumstances, whether that is viable or not. It is a very fact specific. Now, there are assets that we can think about today also in our context, such as the Google search algorithm, which were never disclosed in a patent application and are maintained as a trade secret and continue to be optimized all the time, obviously. But we need to bear in mind that as more and more companies are delivering innovations actually as services rather than as products, and they do that many times in order to avoid taking those innovations out from behind their walled garden, if you would like. Trade secrets would continue to play an increasingly important role in that context. Next slide, please. And this is very much the case in the case of the issue, in the case of a cloud computing environment. We see more and more mobile cloud applications and mobile web applications which are similar, and because they both run on a server that is external to the mobile device in question. So, unlike a cloud-based app, a native mobile application, that is a normal application that is running on your actual device, is downloaded and installed on your mobile app. Now, there may be there are various technological hurdles, but that does enable an interested party, is not necessarily law-abiding also, to take this app to try to work it backwards and to understand how it works. That is not possible in the case of a mobile app that is run in a cloud environment, simply because you do not have, even if you decide to break the law here, as a reverse engineer, you cannot work it backwards in order to access the code or the software architecture in question. The only people who have access to that code are the developers and the employees and the people that operate, some people that operate the cloud, if at all. All of these people may be bound by a secrecy, a confidentiality obligation, right? This thing, those assets can be maintained as a trade secret. And once they are, simply no one can actually access them. So the people who are bound by trade secret law cannot, they access them, but they cannot make any use of them. And all the other people out there can just not access the code or the architecture. Of course, in order to have an effective trade secret obligation in place, there are certain steps that you must take. and this is not the time and the place. It's probably a topic for a separate discussion. What are the four corners of an effective non-disclosure agreement within the realms of technology, especially? But you must ensure indeed that this is what you have in place. I believe that this is it when it comes to code and architecture for our purposes now. Let me move on to the next facet of our mobile app, and the more important one in my view, in a lot of context, and that is the GUIs. The next slide, please. GUIs, a graphical user interface or user interface. It's the screen display. It's the very thing with which the user interact with the service or the product in question. Next slide, please. Now, I have a fairly long quote here of David Kapos, who is the former Undersecretary of Commerce for Intellectual Property Law and the Director of the US PTO under the Obama administration. Now, I'm not going to go with you and read the whole, you can look at it in your own time, the whole quote, but David Kapos is referring here to the increasing importance of design and how various intellectual property rights should be or may be used in combination in order to protect such design. In the end of the day, this is indeed where in most cases your value lies. It is in the design of the mobile application, of the GUI. If the design in question is intuitive, if the user interface is intuitive, if it is user-friendly, your app is much more likely to be popular and vice versa. It doesn't matter how technological advanced it is. If it's not intuitive, if it's not user-friendly, if it doesn't attract and appeal the user in these contexts, it is not likely to be successful in most cases. Pardon. So let's try and move. Let's try and move to the next slide, and let's look at the various intellectual property rights that play a role in this context. If may, just a second. Let me just change the light here because it's a little bit blurred for me, but this is now better. So if we can move to the next slide, please. Copyright. In the context of GUIs, what does copyright protect? Well, both the text, the visual elements, moving as well as static, and a combination of text and visual elements. But what you need to bear in mind is that in order to be protected under copyright law, it must be original in a copyright sense and not dictated, as we said before, by functional consideration. We have to be mindful of, as I mentioned before, of the idea-expression divided, the idea-expression dichotomy. Frankly, in the case of copyright, unless somebody is in the business of making a verbatim copy of your GUIs, it is not difficult to avoid. So I can capture the essence of your app without infringing your copyright if I know what I'm doing. By the way, that brings me to a point that maybe I should have made a slide ago, and that is the reason why a GUI is one example as to why the GUI is so important is that if I want to have an app that would compete with yours, and I basically want, to an extent, to free ride on what you're doing, I can bring the app in question to a skilled programmer, and I can say, and I can ask, can you make me one like this? And they can make, and if they know what they're doing, if these are skillful programmers, they can probably create an app which is very similar in the way it appears, that's the GUI, and the functionalities, without copying one line of code. They don't need access to the code. They would write fresh code that would make an app to behave in a similar way, to look very similar to the one that I have. Hence, protection for the actual GUI is of great importance. Now, when it comes to copyright, as I said before, you must remember that, or you should remember that it needs to be original. And when we talk about original, in the case, I mean generally, but in the case of a mobile app, what it needs to be is something which is not commonplace or trivial. It doesn't have to be creative. So GUIs, which are by and large involve a combination of commonplace elements, are more difficult to protect by copyright, although maybe the way in which you arrange those trivial elements could be subject to copyright protection. But again, if someone knows what they're doing, I would think that it shouldn't be that difficult to avoid being caught by copyright while still capturing a lot of the essence of the mobile app that one wishes to, let's say, be inspired by, right? I'm not saying copying. Next slide, please. Trade secret. Well, in the case of GUIs, it's mainly pre-launch. Once you launch an app, whether it is cloud or not cloud, it doesn't matter. The GUI, the code and the architecture may be on the server, but the GUI is on the actual mobile device. And therefore, to protect a GUI through trade secrets, it is not very effective post-launch. Patents. There is an example here for a patent, right? It's fairly basic, but nevertheless, I mean, you can have a look at it in your free time. What you have here is really a patent where you have an icon for an app. And what is happening here is that the size and the location of that icon representing that app will change according to the amount of use. So more popular apps with you, right? The device senses that you use more, the icon will become a bit bigger and will be positioned in a more prominent position and so on. So yes, we can have patents. Utility patents, as the Americans call, so patents as we know it in the DPO. You can have patents for GUIs, but it is tricky for the reasons that I explained before in relation to the actual functionalities and the architecture. In the case of a GUI, even more. I mean, if you look at the EPO, where I believe it is quite clearly more problematic than in the United States, it used to be different. Up until 2012, I believe, patents were granted a little bit more freely in relation to graphical user interfaces. The court or the boards were prepared to accept as a technical effect what they call the lowering of cognitive burden. In other words, if you would show or if you would convince the patent office that your app is more user-friendly, so it requires less energy, less effort for using the app or using the device. You could have been successful because you would be able to argue then that you lowered the cognitive burden of the user. That doesn't bite anymore. Unfortunately, if you are a patent attorney, I assume, and a mobile app developer. So these those spring days for GUIs are over. Such lowering of cognitive burden is not accepted as a technical effect anymore. So this is why I write here a psychological effect. Bad. That's not going to help you. in claiming that what you have is a technical effect. Physiological effects, good. So if you show, for example, that you have a mobile app that involves a certain user input that makes it, for example, more effective in terms of there's less of a burden on your eye, on your hand, and you can actually establish that as a matter of fact, you may be successful. But again, how many apps do we have where you can show that? Next slide, please. Trademarks. Again, trademarks can be granted in relation to the overall layout of a screen display or a GUI, individual static components, such as icons, and also transitional or animated features, right? Moving features. You can gain a trademark registration in relation to any of these facets of a GUI, both in Europe and in the United States. I'm not entirely sure what is the situation in Brazil. I'll be happy to hear about it later. There are a couple of things we need to bear in mind in terms of trademarks and those hurdles to trademark protection in the case of the GUIs. Next slide, please. Next slide, please. Next one, please. Can I please have the next slide? The next slide, please. I think I ran through a number of slides. Yes, thank you. Trademark. So there are a couple of things, as I said, that act as a hurdle or hindrance for protection. First, two exceptions for trademark protection and registration, both again in Europe and in the United States. I believe that in Brazil as well. Maybe proved wrong on that. And that is functionality and aesthetics. So both a trademark application or for a mobile app may be excluded or rejected on the basis of both characteristics. So if you have a characteristic, which is in that case a GUI or part thereof, which is aimed at achieving a functional objective, that may not be protected under under trademark law. The same applies to something which is designed primarily for aesthetic purposes and therefore add value to its aesthetic nature in the sense of its eye appeal. If that is what you seek protection for under trademark law, your application may be rejected under such circumstances. Next slide, please. On top of that, there is the usual requirement or the ordinary requirement for distinctiveness, right? Distinctiveness can often be a challenge in this context. Next slide, please. Here I'm just giving you two examples of decisions of the European Union IPO boards of appeal. First bullet point applies to the first icon, the camera icon, and the lower bullet points apply to the lower icon, the contact icon. I mean, everyone who has an OIS and is familiar with those icons. And it was rejected in Europe in both cases for lack of distinctive character. Interestingly, it has been recognized and registered in other jurisdictions, but not in Europe. Not at the EU IPO. Again, not for aesthetic or functionality, just lack of distinctive characters. You have those decisions there. Those of you who are interested can follow it. Next slide, please. Very interestingly, design protection, extremely effective in the case of GUIs. In Europe, we have a registered community design. In the US, language is a bit different, design patents. as opposed to utility patents, much closer to registered industrial design as we have it in Europe. And in Brazil, I understand you have also a design patents. In all cases, you can register as a design. In all those, all three jurisdictions, you can register as a design, both a GUI, so the screen display as a whole, and the design of an icon. The design of an icon. My apologies for that. Yes. Now, I'm going to finish off with the next slide. Next slide, please. And that's a question. Now, functionalities. It is. You have here the now fairly old, but a few years old instance where Instagram, if you would like, decided that the stories function on Snapchat is worthwhile having, and basically appropriated it, right? So Snapchat at that time was the only one. They came up with this concept where you may have a story, friends can comment on that story. The story or the video is available for 24 hours, and that's it. Snapchat it did not pursue any legal action against Instagram when Instagram introduced the same feature into its app. There's even, those of you who are interested, I can provide some information later. There's actually clear evidence by analytic companies where that actually affected, that show how that impacted the number of uses in the following years. There were a lot of people that were holding both apps at the time. Instagram, because they liked Instagram. Snapchat, they liked it as a whole, but they liked especially this feature. Once Instagram had this feature as well, there was little need for those people to use Snapchat. The question, as I said, is why didn't Snapchat go after Instagram, where it appears that they appropriated or were inspired, heavily inspired by that feature, that they introduced the same feature into theirs? And the answer is not because Snapchat has small pockets or shallow pockets. That there was absolutely nothing that they could do. There are certain functionalities which, as a concept, the logic behind the functionality just not be protected. Trade secret will not help you here. You don't need the code. You don't need the architecture. The only thing that you can rely on is your advantage as a first entrant into the market and your body of consumers or customers and clients. And you need to do as much as you can in order to look after those. But there is, at law, nothing to prevent others from looking at what you're doing and saying, you know what, that makes a lot of sense. Great idea. I'm going to have one as well. And me personally, I don't think that's a bad side effect of our legal system. I think, to me, it makes sense. Next slide, please. With this, I will end. Thank you.
Noah, thank you very much on behalf of the Brazilian Intellectual Property Association for the masterclass, touching bases on very different topics of mobile applications as regards IP. Now you see that there is also stories in the LinkedIn as a feature. I don't think it matches well with LinkedIn, but some people think it does. But it's there on LinkedIn. So thanks for touching base on different things. I mean, we have very similar approaches in the Brazilian law. So whenever, for example, you mentioned the impossibility of protection when it's a functionality requirement, And we do have this kind of restriction here. You mentioned the lack of protection for methods, projects, mathematical concepts, roles, plans, and of course, this is also in our copyright law, so it's also covered in Brazil. So we see the same sorts of discussions around here. Most of the protection for software is for embedded software, so it's kind of whenever it's embedded in an invention. So that's why you could, protect some software as patents, I would say. So most of the protection for patents, patented software is when they're embedded. So that's, again, another discussion within our community here in Brazil, because it's not very common to receive patent protection for software anyhow. And then you mentioned trade secrets. Again, this is a very practical thing because, employment agreements would be necessary, assignment of copyrights, and we are also always looking into that because, you have the protection there, but if you can't enforce those rights, then you have a problem. And in every due diligence, that I've been involved with, those will appear somehow, because there was a lack of, and when you think about mobile apps, you think about, very smart, creative young people that will be developing things, but they're not willing to sign agreements, to assign the rights. So in the end of the day, you have a mess, and it's very difficult to, to ensure that a company would have the proper rights. So we try to do that here as well. You mentioned the cloud apps, so that was very, the protection by trade secrets, that could be an option. And finally, and it's the same here, and finally, the graphical user interface and the possible combination of different rights. And I think that's the same approach we take in Brazil, possibly copyrights, trade secrets, patents, trademarks, and designs. So this is also in line with what we do here. So very similar to the references you made. So thank you very much for all of this. And without further ado, let me introduce you to, go ahead, Noam, you had anything to say?
No, okay. I was thanking you back. Cheers.
Yes, okay, thank you very much. And so let me introduce you to Mr. Dimiter Gantchev. He's the Deputy Director of the Copyright Management Division in the Copyright and Creative Industry sector of the Wipo in Geneva. He works on issues related to the economics of copyrights and related rights, copyright infrastructure and management, and in general, the potential of copyright for generating income streams and making a living. He's involved in economic studies, delivers capacity building on direct management of intellectual property assets in the creative industries, and develops public-private partnerships for transfer of knowledge in the creative sector. Mr. Gantchev has been in charge of research projects in Wipo, establishing methodologies for assessing copyright impacts and providing evidence for policymaking on copyright and creative industries. He's a national of Bulgaria, holds a PhD in economics from the Sofia University of National and World Economy, and an M&A in international relations from the Moscow State Institute of International Relations. He's a founding member of the Bulgarian National Association of Intellectual Property and has numerous publications on creative industries, intellectual property, and foreign policy issues. He's a frequent speaker at major international and national events on creative industries and copyrights. Mr. Gantchev, again, thank you very much. It's the first time we met, but we met in the discussion before these IP talks. But by coincidence, my dissertation for Queen Mary was on the involvement of creative industries from the starts of creative industries in Brazil until the digital millennium there in 2000. So again, it will be very interesting to hear your thoughts and your lecture on that. So thank you very much on behalf of the ABPI, and the floor is yours. Thank you very much.
Obrigado, Fabio. It is a pleasure to participate in this webinar, and I'd like to thank ABPI for the invitation and for sharing together with us the initiative and the organization of this event. I'm very glad that you started off with the creative industries years ago. It is indeed a subject which has become extremely popular around the world. And we in Wipo started paying much more attention to this subject around 15 years ago. And today there's a whole stream of activities related to creative industries and creative economy in Wipo. Perhaps the difference that we have in comparison with some other institutions and organizations in relation to the creative industries is that we take as a defining principle for the creative industries their level of dependence on intellectual property protection. And this is how we delimit the scope of the subject matter of the creative industries. So our activities in terms of the creative industries have gone into two directions over time. The first one was looking at the economic impacts, coming up with various methodologies that could assist countries in assessing what is the potential of the creative sector. And the second stream was to look at what do creators need in order to operate their businesses better. How can they identify and how can they manage the intellectual property in the respective creative sectors? And that resulted in a series of hands-on publications and tools for creators on how to make a living in the creative industries. We started off with the publishing industry, which is the biggest creative sector in most countries. But then we expanded on to quite a number of other areas, among which you will find music, of course, film, video games, and mobile applications was one of the latest additions to this list. Mobile applications for developers. And that was the title of a publication that we did together with Dr. Shemtov. And I'll be happy to share with you the link so you can send it to all of the people who are watching us or who might take interest in the subject. Now, why mobile applications? Mobile applications, it's clearly one of the most successful and dynamic parts of the creative sector, standing today for a business of close to $190 billion. And we've got more than 20 million developers around the world, which means that this is quite a popular thing and people do it for various reasons. But there you go. You have a sector which is growing at about 27% annual growth rate, which is really one of the fastest growing parts of the creative economy. And you've got 5 billion mobile users in the world. So there is an enormous market for mobile apps, more than 60% of the world. So clearly mobile was very popular. People could link to it immediately. And we looked into that industry, an industry which is a significant job and value contributor to the economy. And as an economist, I can tell you that there are a lot of challenges in identifying and assessing empirically what is the exact impact of mobile apps, because they are linked to so many other areas of creativity. The mobile app industry is also part of the startup economy. A startup economy is something which every government puts in the center of its economic policy nowadays. Mobile apps are not just a distribution channel. Mobile apps have become a huge distribution channels themselves, not just somebody else's content. They're not just instruments of marketing, but they are a big, important channel of communications. And today they're used for entertainment, for productivity, for reference, communications, enterprise solutions, you name it, almost everywhere. And what drives this app economy, as we call it? I would mention just 4 of the main drivers of this economy. The first is, of course, the ubiquity of the smartphones. This is widening by the day and prices continue to decline. The second one is that more than 75% of the world is mobile enabled, which means that having fast internet access combined with this highly intuitive and flexible user interface of smartphones, is a prerequisite for a very successful industry. Thirdly, we have a great level of accessibility of apps via the various app stores. That means you have a convenient access to those apps through the stores, and it is not a problem for anyone to get on the app that she or he may need. And finally, I would say that an important driver is the proximity to the targeted user group, because apps can offer you a very personal user experience, which websites cannot give you. So there you have a very important advantage, which certainly plays a role in the expanding market of mobile applications. So what we did with mobile applications is that first we commissioned this publication, and as a result of discussions and some editorial work, it has appeared finally. And then we developed an interesting project within our Committee for Development and Intellectual Property. The project is called Enhancing the Use of Intellectual Property by in the software industry, with a focus on mobile applications. Interestingly, the project was initiated by Kenya, an African country with a very strong and growing software community. And the project started off last year. As a result of this project, we are producing various interesting tools which might be of interest to Brazilian developers. The first of these tools is going to be a tool on alternative dispute resolution for mobile disputes. And that is actually something which we have just finalized and we will make available in the coming weeks from our website, taking a very close look at when and how and why mobile app developers could resort to alternative dispute resolution mechanisms and what does Wipo have to offer in this regard. The second tool that we're working on is a tool on commercialization of intellectual property through mobile applications. And that is a publication which is again very much hands-on, looking at the life cycle of a mobile app and how the intellectual property there can be monetized at the various stages using the various instruments. So we hope that it will generate some very practical insights and interest in the audience. The third outcome of the project will be an interesting handbook on IP issues for mobile contracts involving mobile apps. How should these IP clauses be looked at, and what are some of the guidelines on how to deal with that in your contractual practice? That is a handbook written by practitioners, and we hope that much of it will be relevant also in different jurisdictions, but at least it lays out some interesting principles. So it is again a very practical use. And the final tool that we are preparing as part of this project is a toolbox, an IP toolbox for mobile app developers. Again, something which would offer you an array of options of what kind of IP mechanisms may you choose in different circumstances, what can they give you, and without prescribing the most successful one, we're just offering you a set of options. So this is the idea of the toolbox. Again, all of this is supposed to be ready before the end of the year, and it will be available from a dedicated website on this project about enhancing the use of intellectual property by mobile app developers. Now, we've had a few events in some of the beneficiary countries for this project. So what can I tell you? What are my impressions from these events? Those events were on workshops in the good old days when we could see each other in the face. So what these workshops tell us, my first impression was that the developer community does not have much knowledge on intellectual property. Most of the people had no clue what are their intellectual property assets, what can be protected, and why should they go down that complicated road. So there was a lot of hesitation among them. When should I go there? What is the threshold? When should I start worrying about my IP? So as a result of this, we launched a series of educational material. They will appear as videos as well from this website. And I will recommend to everybody who is interested in that to check them out. Those videos are ready. We are just launching the website, as I said, in the coming weeks. My second impression was that the mobile app developer community was highly disorganized in the countries where we were. And those countries were Kenya, the Philippines, and Trinidad and Tobago. These are my direct impressions. And I had the pleasure of working there together with Dr. Shemtov. So we were able to speak with many of these people, and we saw again they're very disorganized. And in most of the cases, they did not see the point of putting together some form of, organization, or you may call it just a group united by their common interests. So we gave them as an example some countries where this professional group has come together. One such example is the Mobile App Association of the United States, which is partnering with us on this project. And they are giving a wonderful example. What can you do to protect the interests of the community, and how can you help them actually to perform better? So there are quite a number of interesting ideas that can be picked from this national body. And again, our advice was that if mobile app developers would come together and find an interest to work together on some issues, perhaps that can pay back to them, and they can do a much better job in protecting their interests. In some cases, the mobile app community was put together with the software developers. That may be natural. However, with software, you have some bigger issues which are not typical for all the mobile apps. And I found that that has not always worked in their interest if they're put together with a much larger group. What comes another point which is, in my view, interesting is that we saw a lot of interest from the academia. A lot of research institutions came to our events, and they were all interested in integrating more specific IP elements in their curricula, as they have a lot of students which are studying computer science and other related subjects. So perhaps introducing IP knowledge already at the level when they're building up their skills and their basic knowledge in this area, that might pay off very well in the future. So we have started a dialogue with those institutions, educational institutions, and see how we can help them to become more interesting for the future mobile app developing community. These are some of the issues I wanted to mention in relation to this project. It is just one of the CDIP projects, the Committee for Development of Intellectual Property in Wipo. And Brazil has been an important partner in casting out the agenda of this committee. And perhaps also thanks to you, this activity is taking place. Your interest has been a driver for many of the actions which the organization has taken in this regard. Finally, I'd like to say that if there is an interest in Brazil to this subject, we could think together with my colleagues from our office in Brazil, how can we help more specifically the Brazilian mobile app community? And I think this is where I should rest. Thank you.
Mr. Gantchev, thank you very much for this very thoughtful and very rich impression on the creative industries and the potential of the creative sector. Thanks for bringing all those numbers. I mean, I think those are very important for us to understand that it's a very it's a growing market that has a space, and although it has a space, it's still a bit disorganized in a number of countries. And I think we have the same sort of problem in Brazil in some areas, although we are already educating most of the startups in Brazil so that they can develop, knowledge and content in a way that IP is protected and used, of course, as a revenue stream. So thank you very much for telling us about the initiatives of Wipo in that regard. So I would welcome your support and materials. Whenever the videos are in the platform, let us know, please. And we can spread that out within the community here. So thank you very much for providing us with this valuable information. I would like to open the floor for questions. We have a qualified audience there, like a VIP audience, as we call it. And I have a question I already have a question here. So Erica, let me know if the audience can make the questions themselves, or if we should be reading the questions, so how it will go. I mean, we still have 12 minutes, so we are on time.
Fabio. We now have time for questions, and I would like to know if some of you would like to make a question. If yes, please raise your hand. Mr. Valdir Rocha wants to make a question.
Good morning.
Good morning. Well, you have to unmute your microphone, please. Thank you.
Hear me?
Yes.
Can you hear me?
Yes.
So, no.
A very interesting question indeed. I would before commenting on the situation, the position in the UK, I would just say that indeed, as you mentioned, registration in multiple jurisdictions is costly, but and while unfair competition doesn't require any upfront costs. And again, it's a trade-off. However, I do not know how it works in Brazil. I'm sure you can inform me. But bringing an action for unfair competition, the enforcement, be more costly than in the case of a registered trademark. Because you would have, for example, in the United Kingdom, I would say, on average, as a general rule of thumb, an action for passing off would be about 50% more expensive than an action for a registered trademark, because you need to prove or to establish the subsistence of your right, what is a presumption in the case of a registered trademark. Now, in the case of the United Kingdom, an action of passing off is possible if and only if, and this is why it's a very limited form of unfair competition, if you can show public deception. So when people refer to passing off in the UK or in common law countries as unfair competition, I think a more accurate form would probably be unfair competition by misrepresentation. You have to show that there is misrepresentation, which is not the case, for example, in Germany or in France. If you would go to Germany or to France for unfair competition, for example, in France, you have two branches of unfair competition. One is disloyal competition and the other is parasitism. And under parasitism, you may be able to bring an action, notwithstanding any confusion. So in the UK, in short, the answer is in the UK, possible, but there has to be deception, and it would cost you quite a bit. Yeah.
Thank you. Very good. I think Beatrice has a question, right, Erica?
Yeah. Yes. I believe you can hear me.
Yes.
Can you hear me?
Yes.
Okay, wonderful. Good morning, everyone. Thank you so much for the invitation. It's a pleasure to be in such an exciting event with so many new information. Dimiter, it's great to see you again after so many years,
Yes,
I have to say. And always exciting presentations. And Noam, thank you so much for all the data and information that you provided. I wanted to make a quick comment based on one of the points that Noam presented. He mentioned designs, right? The importance of designs in this context of mobile apps. And I wanted to bring to everyone's attention, as most probably know, Brazil is looking into joining the Hague Agreement on Designs. And we, as USPTO, are actually working together with Brazilian INPI so they can get more familiarized with the agreement, how we implemented it. And we are actually doing work on that combined with our colleagues at Wipo. Actually, we have an upcoming event on that topic that will congregate examiners throughout Latin America to discuss Hague. And of course, we are doing that through our headquarters, coordinating with Wipo headquarters. So I just wanted to flag that to you all, because indeed we see in our USPTO headquarters important growth in the number of design applications, and we believe this is going to be a global trend, and Hague is an interesting instrument for that. So we are working with Brazil on that.
Very good, Noah. I think it's, go ahead. It was just a comment. I would want a question, but
I would like to second those observations in terms of the increasing importance of a registered design. I mean, we have seen a very serious uptick in the number of registered designs in Europe. Interestingly, in Europe, there is no examination up front. You have to tick the boxes administratively. You need to pay the fee. I think the fee today is something like 350 euros. Within 24 hours, you get your registered designs. It is upon enforcement yes, the validity, if you would like, would be assessed. But there are a number of sectors. Luxury goods and fashion come to mind, where you saw where we see a serious increase, but also in the area of tech, GUIs is one of them indeed.
Very good. Other questions, Erica, from the VIP audience or from YouTube? Do we have anything else?
No, I don't have no more questions.
Okay. So any final remarks from the speakers?
Dimiter, please.
It is a pleasure to be able to speak at this event, and I hope it will be one of many on various creative industries. Brazil is one of the leading countries in terms of developing the creative sector, and we'll be very happy to share whatever knowledge we have and whatever experiences we have in various specific creative sectors. I'm glad that we started off with such an important sector for your country as well, mobile apps. So let's look into other candidates and see how we can be relevant for your work.
Thank you very much, Dimiter. We will count on you for future events and for sharing the knowledge with us on those initiatives from Wipo. So thank you very much on behalf of the ABPI. Noam?
Thank you for the invitation, the opportunity to speak to what I understand is a fairly large audience, and for some of those interesting questions and observations that I had the opportunity to experience during this event. That's about it. Thank you.
Okay, thank you very much on behalf of the ABPI. I hope we manage to have a pint very soon, once all of this is over. And take care of yourself. And thanks again for being with us today and for sharing that information and knowledge about IP on apps. Thank you very much. Erica?
Thank you. Thank you, everyone. The complete video will be available in some hours at our YouTube channel. And we appreciate you being with us today. See you in our next IP meeting. Thank you.